We exist now. Can everyone hear me? That's good. Okay, a couple of things. First of all, there is the makeup shoot at 3 o'clock, I think it is. There were two, but the other one's been scrapped. Secondly, you might find when going through and looking at the slides for this subject that the headings, particularly the high-level headings at each time, they look a bit sort of broad or vague. That's a little deliberate. I mean, basically what I find with this subject is that there's lots of little bits of information all over the show. And so just in terms of compiling those, taking the bits that Tom wants us to learn, taking the bits that Nicola wants us to learn, combining them sort of together has ended up with some quite broad categories. So when trying to look at all the material from this week's material, this lecture, trying to work out exactly what it is that they want us to learn and how that aligns with the subject itself. I think in the broader sense, it's to do with certainty, or the three certainties that we have in terms of trusts. I think that was really the overall category, even though this is going to be lots of little bits of information. And so sometimes it's hard to look at that bit of information and this bit of information, really be able to tie them together. But I think broadly that's really what this stuff is about. And this is a repeat of last week's, where we're looking at this requirement. And they'll say things like, oh, these are the elements of certainty in terms of a trust, but it's not really. Some kinds of trusts have the first two, and the third one, in terms of objects, is sometimes phrased in some texts and by some judges to say that charitable trusts don't have certainty of objects. Some of them say they do have certainty of objects, but the object is a purpose, rather than fixed and discretionary trusts that are always going to have beneficiaries as their objects. That's just something to note, and again, you'll see it in different texts, and you'll see it probably for those that have access to Nicola's and or Tom's recordings. Somebody asked me about Nicola's recordings. They're actually embedded in the PowerPoints. So if you want to hear Nicola talk away to each of the slides. But the slides and the layout of the slides is quite different from Tom's as well. Okay, so just be a little bit mindful of that. So last week we talked about certainty in terms of trusts, that needing to have this first one, which is intention. And the analogy is with contract law. In a contract, who needs to have intention? Both parties. When we're looking at trusts, in particular just discretionary trusts, this certainty of intention for creating a trust is the intention of the set law for trusts that we create. Trusts by operation of law don't have a set law. They don't have a set law. And in terms of intention, often trust by operation of law can occur in situations where neither side in relation to that trust actually intended for there to be a trust relationship. The certainty of subject matter, mentioned last week as well, which is to do with knowing what the stuff is that the trustees have to deal with. And that's important because we've got to go through and actually giving duties to people to look after property for the benefit of others. Well, what's the property? You have to know it in order to be able to do stuff with it. And the other side of that is also the ability of the court to make orders. The court has to know what it's dealing with as well. And we'll talk about the certainty of objects that either to do with beneficiaries or charitable purposes, which makes up really the bulk of the material from today. And you guys are aware that in this, while it comes out as a lecture and it's recorded and streamed and so on, you're more than welcome to just pipe up and ask questions and turn it to something more of a seminar. And I recommend that we do get involved where we can. Okay, so we'll start with express trusts and start with intention. We'll start with Joe Liffey, or Joe Liff's case. I mentioned this last week. This was where a gentleman created a trust, or at least he tried to argue that he didn't create a trust, by writing, when creating a bank account, that it was for his wife's name, comma, also held in trust by Mr. Joe Liffey as well. And so the whole purpose of that, or his purpose at the time, wasn't really to create a trust. It was actually just bypass state banking regulations of the times. And in Jollif's case, the High Court said that that's okay. That's okay. We understand his subjective intention was to not create a trust, even though he used the actual words trust as part of it. And that stood as good law for a long time. But relatively recently, the High Court re-examined this. And it actually sounds a little logical when we express it. When we look at contracts, and you're looking at the intention of the parties, when you're trying to, you guys remember this, when you're trying to interpret a contract, you're trying to look what it is, what did the parties intend when they came together to have this meeting of minds? But you can't actually examine what subjectively they were doing. The court, since Cadalpha anyway, looks at the objective intention of parties when you're analysing a contract. And that is required for commercial certainty. When people are entering into arrangements and looking at contracts, it's not about what the actual parties thought, about what they were promising. It's to do with what a reasonable observer looking in on that situation would think the parties intended to do. It's not about their actual intention or the subjective intention. It's about this third-party objective test for contract law. And what the courts in Burns and Kendall did was said, look, that really should apply to trust as well. It seems a little bit silly to try and get in the heads of parties and the minds, in this case, of the settlor, to try and work out what it is that they were doing when coming together to create a trust. So we are going to use a reasonable person test. It's now an objective test. That's a relatively recent change. And look, that's 10 years ago. I mean, that's very, very recent that the courts came to this conclusion. That subjective test has been around for a very long time. And when you guys are looking at instruments, like today during the TUDE, that's something to leave on the back of your minds as well. It's not what the person drafting it thought. It's not what, strictly speaking, what the settler thought. It's what a reasonable third party would, when looking at it, would objectively determine the settler's intention to be. All right. So there's a couple of other things to note, and this is really a practical issue, and that, who has just recently done land and personal property law with Associate Professor Chris Davies. Anyone done that subject just recently? Well, you vaguely nodding around the room. Oh, yeah. Some of you might have done commercial law with Tom, but you may or may not remember the assignment of equitable rights. Remember that sort of stuff? To assign an equitable right requires things to be in writing, consideration. Was it section 200 of the PLA? Strictly speaking, assigning money, giving money to someone else, doesn't need to be in writing. Strictly speaking, you can create a trust orally. You'd be crazy to do that. You'd be absolutely crazy to do that. And there's a variety of other items of property, intellectual property, land, and any of the sort of equitable choices as well, that have to be in writing anyway. And you guys know what a deed is. Deed is a solemn instrument that bypasses consideration, and it's established under statute. And so you'll find, and again, today we'll go through and we'll use one in the TUDE. So just make note, while strictly speaking you don't need one, it bypasses the writing aspect and satisfies all of those provisions in the PLA, stuff that would have done in equity and in land law and possibly in commercial law, those that have been around for a while. And tax as well, FC10 and Everett. Okay, now, when we're trying to work out what that intention, and again, objective intention test, we're trying to work out what the intention of the settlor when creating a trust. And this is the sort of stuff you probably get examined on too. The first thing you have to know is that there's this distinction between giving property to somebody and saying give it to another party. That's got a power of appointment. That's common law, series of rules. These power of appointments can say, I give my house or boat or whatever to Noel to then give to my children. That's a common law series of rules. And you can express this in a certain way. I give unfettered access to Noel to give my house to anybody except my children. We call it a hybrid power of appointment. These are common law things. And if they don't follow those instructions, somebody can go to court and hold them accountable for ultra vires, for actually doing something outside the scope of their power. But it's not a trust. A trust must have this mandatory language requiring a trustee to do something. Remember that fiduciary duties impose a really high burden on the person who's essentially undertaking to become that fiduciary. Company directors have set quite a high bar in terms of what you do. As employees, it's always strange when I say this, us as employees actually owe our employers the fiduciary duty. We can't run off with all of the secrets of our employer and give them to their competitors. We can't run off with the customer list and give it to their competitors. We are actually held to that high standard by the law itself. And as trustees, as status-based fiduciaries, they're held to account. You're held to account at a very, very high level, to be honest, to not misuse your power, your position, the information, or in the case of trustees, the property, and applying it inappropriately. So, when creating a trust, you've got to be really clear about it. And Missouri Bank and Raynor, I give my property to my wife, trusting her to be, what was the phrase they used? To use her judgment, to use her knowing or trusting that she will use this property appropriately when, and to give it to the children when not required by her. And the courts went through this and had a look and said, what are you talking about? These words that are used, they're too vague. They're precatory words. Precatory means neutral. They're not actually mandating the wife to go and do these things. They say essentially acting like guidelines for her to go through and do that. And later on, we also look at not required by her in terms of what that means in terms of the actual subject as well, subject matter. But you have to be really clear when you're telling somebody, take my stuff and do this specific thing with it. Hold it on trust for my children, maybe a please at the end, and usually in writing. Make it really, really clear, because using this vague, wishful language, hope, wish, or desire, isn't going to be sufficient to be a trust. So that again, if you get assessed on something along those lines, the problem scenario has, I have faith in my husband to hold on to this property and give it where he sees fit to X, Y, and Z. It's not going to be sufficient. Those are precatory words. So that particular phrase, precatory language, insufficient to create a trust. Strictly speaking, they're neutral. They don't negate the existence of a trust, but they're not going to be sufficient. It's possible if you were looking at other things, and again, objective intention test, you could look at other actions the person was doing. That may still be that a trust is created, but those words alone won't be sufficient. And the word trustee itself wasn't sufficient in Joliffe's case. He put the word trustee into the instrument. And there the court looked, again, Joliffe's case, they were looking at subjective intention at the time. His subjective intention wasn't to create a trust. And there the court said, even that word in isolation might not be sufficient as well. Make sure the language is clear. Make sure it is mandatory. You are giving your property to somebody and imposing a duty upon them. Make it really clear that that's what you're doing. And so when we're looking at intention and you're trying to work out, okay, language needs to be very clear. What are other factors that the courts are going to look at in relation to intention? Now, Most of you guys have studied criminal law at some stage, maybe recently, maybe you're doing it now, but all of you ought to be aware, we don't use the word intention much in the criminal law, at least not in the Queensland criminal code. Why? Because it's real hard to prove. You can't just chop somebody's head open, have a look inside and go, oh, look, yeah, you actually did intend to do this. That was your actual desire. That's not how it works. Intention is about looking at the circumstances and all of the surrounding facts, looking at what, in criminal law, what the accused actually was doing. What were the preparation steps that they took? What were the conversations that they'd had with other people? You can't chop their head open and determine what it is that they were thinking. But a really strong indication of a trust is, in commercial sense anyway, is having a separate bank account. There's a couple of cases that come up. The most recent one was Justice Gaylor. Went on a bit of a rant in regards to this, but also Re Caford, case I mentioned last week, and Quistclose is the classic one. If you set up a bank account separate from your other funds and call it the Customer Prepayment Trust Fund, it's far more likely that the courts are going to look at that and think, okay, that actually does demonstrate the intent to have this as a trust. It's a really, really big thing. For those that did trust accounts with me earlier this year, I would have harped on about this, waving my arms, that it's really, really important when you're doing trust accounts to not mix your money, your office account money, your firm's money, and the trust account money. It's that very, very clear separation. And in trust law, leaving things separately is a really good indicator that, in fact, you did intend to create a trust. Okay, and all right, so again, I draw a lot of analogies in this subject on contract law, largely because you guys have done contract law, also because I've taught it a lot more. And it's useful, I personally think, when studying a discipline, to see analogies and similarities between other aspects of what it is that you've been learning. Some things are going to be the same, some are going to be different, but to be able to compare those things, I think, is a very, very useful mechanism for reflection and learning. And for those that have ever had me teach you contract law, waving my arms, say things like, the court is not the destroyer of bargains. They will bend over backwards to uphold a contract and make sure a contract is found. And it's the same with trusts. The court doesn't want to be the destroyer of trusts. For a couple of quite pragmatic reasons. Trusts are usually set up for the benevolence of, I'll loosely say, weaker people, children and family members and so on. And they're done for a reason. This is express trusts. And as such, the courts will try, sometimes they try in very roundabout ways, to find or hold that a trust exists. And also appreciate that contract is common law. All right, at the end of the day, it doesn't care how fair things are. It wants to be upholding the bargain, upholding a contract, just to maintain the consistency of the law. And its purpose is to do with commercial certainty. Here, though, we're in equity. This is a court of conscience. We care about what's actually going to happen to the people involved. And so, I'll talk reasonably briefly about the Police Association of South Australia, that case. And I guess it's a little bit sad. Usually torts, particularly torts B, they're all the sad cases. People jumping into rivers that are too shallow and so on. Trust is usually the opposite, and it's just relatives arguing about money. There's millions of dollars. Who's going to get it? Not allocating costs, we're allocating stuff. In this case, though, it was a police officer, female police officer, the name of Miss Faithful, and she had signed up to the insurance scheme, life insurance or assurance scheme that the South Australian Police Union had. Sure. And she was married. She was married to another police officer. And she had a will. And she had it all structured. So she filled in the nomination form. And you're filling in the form, fill in the nomination form, and it says, if I die, money's going to go to my husband. Sure. That's pretty straightforward. Okay. Now, a couple of things, a couple of points that I would have talked about in this case, and just for your own general knowledge. When you have a will and you're married, and you get divorced, you need to make a new will. Those that have studied succession a little bit more recently than me might be able to know the section. I'm not sure the section of the Succession Act, but it will, at common law as well anyway, it'll essentially terminates that will. Doesn't mean that your intention isn't still enshrined in a particular document. The courts can't look at that if you're strictly speaking intestate, but you do need to create a new will. Because what happened with Ms. Faithfull is that she left the husband, and they said the nomination form had his name, and then, but if he was to predecease her, her mother. Okay, and that pretty much mirrored her will as well. And so what happens, like anything, who's ever signed up to super funds and then completely forgotten about it? You young guys do that. Make sure at your age, piece of advice, get into one super fund, put them all together, sort it out, and never worry about it again. Because as a person that came to this country and had to deal with super funds and super fund people, they look at you with wide open eyes and hands that go like this. Put it in one place. But she did put it, in this case, this insurance policy, she did put it in one place, completely forgot about it, and then carried on life. And she met someone else, and who became her de facto partner, and they had a child. Little Jordan, had a child. And then what happens to police officers in the line of their work, and the new partner, by the way, was a cop as well. Keeping to your own. And so they were in a pursuit, a police pursuit, and they're both killed. And so now the courts are faced with the situation where there's an insurance payout. Payout's gone to the union. It's actually been given to the, the South Australian Police Association of South Australia. And they had to go and ask the court, what do we do with this? Because the person on the nomination form is her ex-husband. Do we have the power to go through, give it to someone else? Well, no, we're not going to do that because liability, etc. It's up to the court to go through and determine this. And so they did. And the courts in that situation. And what sounds logical to you guys here? It sounds logical. You've got a strict common law rule, which is name on the nomination. That's where this money goes to. But then we're applying principles of equity. And the courts there quite reasonably said, oi, you probably should allocate that money in a trust to the orphaned daughter. Seems pretty logical for us, but you appreciate though that that's not it's not a series of steps that they could have got to when strictly interpreting the instrument, the statute, or the common law. This is one of those areas where equity has intervened, and if you guys as lawyers or future lawyers, it's helpful to leave that on the back of your mind, because if you were just reading the rules here, that money's going to the ex-husband. And that's a pretty harsh result for an orphan 7-year-old. And so the courts actually did say, look, this, even though strictly speaking, this is what the nomination form is, we're going to take a variety of principles. Did you ever study Ronald Dworkin in your first year studies? Taking principles from there and principles from there. We are going to construct somehow a trust out of this. In family law, this would happen. For example, when you separate, children have got to be taken into account. We'll take principles from succession law that says if you die and all of the money would go to some distant relative, your children can still make a claim to make sure they're looked after. We're going to take principles from each of those. We're going to plop them together. And we are going to then determine and create a trust as a result. The court doesn't want to be seen as a destroyer of such things.
I have a question about the Succession Act that
Yep.
says you need to make a new will when you
Yeah.
divorce.
Yeah.
What does that do
Well, I mean, I presume they can still use it when you're trying to determine what your intention is, particularly in relation to people who aren't your husband or wife that's listed in the will and the common law. I would have to go and read the common law rules for that. I'm not sure. Okay. So, just make note, again, you're probably going to have to, you might want to engage with that case. Go and have a read. It's one of those cases that I recommend reading for this subject. Usually when I say things like that, it's because often it's one that gets examined. Okay, but another more broad set of principles that they use is to do with purpose. Quistclose, it's actually reasonably old in terms of our lives, but new in terms of trust law, because it was problematic at the time, and some argue it's still problematic now, in terms of determining and finding trusts in commercial situations. Because this is the real difficulty of blurring the lines. Trust law flowed from this concept of users, and it was really to do with families, and maintained and upheld by the courts of chancery. Before that, your priests. It was the court of conscience that you could come to, where you could get no remedy at common law. But along came the 20th century, and these lines started to get very blurred. And in particular, the idea of using trusts as a remedy. When we do contract law or tort, we're trying to seek a result. What's the result? Usually money. In some set of narrow circumstances in contract law, you can get specific performance, which is an equitable remedy. In some breaches, either in equity or in contract as well, you can get injunctions, which again is equitable as well. Now, usually those are only done in very narrow sets of circumstances. And what has happened in the last 50 years, though, is that some of those areas of equity that had previously been really the domain of family stuff, succession and will stuff, and land law, has moved into the commercial environment and the commercial settings. And this is both through the finding of resulting in constructive trusts by the courts. Remember, I mentioned that express trusts are only half of what we're looking at in this subject. We're going to look at the other stuff a bit later on, which is trusts that occur through operation of law. Resulting trusts, where there's some failure of purpose or to dispose of an interest, or constructive trusts, which is to do essentially a remedy that you can seek if somebody's done something naughty in relation to you and in relation to some aspect of property. I don't think we talked about that, or Rachel talked about that stuff with you in contract. If it was, it'd be very, very, very minor when looking at estoppel, which would have been in about your third week of law school for most of you, so it's probably pretty hazy anyway. But part of mixing and matching the stuff, commercial stuff, and the courts of chancery meant that in some sets of circumstances, in what otherwise looked like arm's length commercial arrangements, from time to time, trusts can be found and can be held, and we have to know and use the principles of equity in order to resolve those things. And Quistclose was one of those examples. I talked about it briefly last week, or a week before, and I'm going to talk about it some more now. Quistclose was a case involving a company called Rolls-Razor. And Rolls-Razor was operating in the 1960s. This was before you had all of this rigorous Corporations Act stuff that says, thou shalt not pay dividends unless thou makes a profit. The sort of things that have been mandated by regulators over the last 50 years or so. But Rolls-Razor was a company, and they wanted to give a distribution to their shareholders. What was the trouble? They didn't have enough cash. Didn't have enough cash to do this distribution, and so they went to borrow some money. Sure, that's the lender, I'm sure, must have gone through it. And look, to be honest, this is the sort of situation where, as a lender, You go through, you look at their books, and you examine what the situation is, and if it's risky, what do? Charge a high rate of interest. It's okay to lend, as a commercial lender, to risky investments if the interest rate's high. All right, yes, we'll let you pay your dividends, but yeah, we're going to charge you 27% interest, compounding daily or something crazy. Now, another thing that the lender did, or asked the Rolls-Royce to do, was when setting this up, put it in a separate bank account. And they did. And some people are not sure whether or not this is relevant or not. A bit of commentary, both one way or the other. Barclays Bank, who were the ones who controlled the bank accounts, knew about this at the time. So they knew about it, signed it off, and said, yes, you can create a separate bank account called Payment of Dividends by Rolls-Royce. Have that as a separate account, manage as a separate account, and then close it again after the distributions are done. Sure, Barclays Bank were aware of that. Barclays Bank were also aware that Rolls-Royce had a bunch of other accounts, including a very large overdraft. All right, and again, I think it's really helpful at this stage. This involves a variety of areas of law, but an important one to note here is to do with liquidation and insolvency. Some of you will study it. Most of you might not, but it's helpful to know when a person or natural person goes broke and their creditors all come together, they can petition to make them bankrupt. That's the term that we in Australia use to describe a person who's got no money and the court has been petitioned. You can owe a lot of people money, but unless somebody's actually gone to court, made an application to make you bankrupt, you might have a negative net worth, but you're not bankrupt. Once it's $5,000 as an individual, they can go to court and they make you bankrupt at that stage. At that point in time, all of your property vests in a person called the trustee in bankruptcy. They have to look after your stuff for a period, usually 3 years. Okay? The idea is that, look, we all need second chances. We all need some mechanism to start again. And it's tricky because our culture, I think Australian culture is I say there's a lot less entrepreneurial, a bit less risk-taking than the Americans, who have a much more open attitude to bankruptcy. And if you haven't got bankrupt 3 times, you haven't tried hard enough. Whereas here, it's a lot more. People are a lot more reluctant to do that. For those that end up doing community legal at some stage, if you're dealing with people, often you'll have debtors that'll come and say, "You owe us money. We want to garnish your Centrelink or what have you." And usually they've got to go down 2 paths: either try and repay the money or go bankrupt. All right, and if they go bankrupt, which is a strategy as a solicitor I've advised numerous times. Often you use it as a strategic mechanism to go back to the person doing it, say, come back with a more reasonable amount for us to repay, or we'll do this. We're going to go bankrupt. But it can happen. The very important thing to note for you guys, if you're bankrupt, you cannot be a solicitor. Leave that one on the back of your mind. It's very, very, very bad if you guys become bankrupt. So just be very, very mindful of that, particularly in terms of your own asset planning and your own asset strategies. In fact, possibly you might end up using the mechanics of trust law in order to do that sort of planning, because it is an extra thing to take into account for us as solicitors. Okay, so anyway, once you've gone bankrupt, the trustee's got all your stuff, and they follow a series of rules. They let you use your car if it's a cheap car. They give you back your tools if you can work, and that sort of stuff. So you can go off and carry on doing stuff. Partially so you can try and repay creditors wherever possible, but if you can't, all of your assets are pulled together and then sold. They're sold, and the creditors are repaid. But they're repaid in a hierarchy. And a similar thing applies, by the way, when companies get liquidated. Liquidate a company is when a company can't pay its debts. The amount is $2,000. And for anybody here that is a company director, even if you don't have to do much else, always check your post box or wherever the registered address for your company is. Because if somebody says that you owe them $2,000 or more and you do not reply and they apply to the court to have you liquidated, it'll happen. That is a terrifying thought, particularly if you've got a lot of assets stored in your company as well. Very similar to when an individual becomes bankrupt, when a company goes insolvent, the directors get booted out and replaced with the liquidators. So they are vested with legal title, and their job is to go through, carry on running the business for a little bit, particularly if it's profitable, but to go through and try and sell stuff in order to repay creditors. It's exactly the same sort of duties that the liquidator has as opposed to the trustee and bankrupt. It's at the end of the day, they don't really care about the company or the person. It's about trying to repay the creditors. All right, that's really important to note because in both situations, there is a hierarchy of who gets paid. And you need to leave that in the back of your mind when you're analyzing trust-related situations, because trusts sit at the very top of this little pyramid. Remember that trusts is about separating the equitable and the legal title? If you can declare that something is actually held on trust, creditors can't touch it. The liquidator can't touch it. The trustee in bankruptcy can't touch it. And that's why you hear these stories about naughty business people that have large houses and yet owe their creditors tens, thousands, millions of dollars and carry on with those houses because they've often in situations like that put stuff in trust. And so when the creditors come knocking, it doesn't, strictly speaking, belong to them. They may have a beneficial interest, but they don't have the ability, or the creditors don't have the ability to grab it, either through the trustee in bankruptcy or the liquidator. Okay. Does this seem pretty logical to you guys? Because that little hierarchy in terms of who gets paid first. So with a company, your secured creditors, if something's not a trust, your secured creditors get paid. That is a person who's lent money specifically charged across an asset or a class of assets. Those assets can be vested back to the people with the security upon them. So in those situations, they're going to get their stuff back. Then you've got the general purpose unsecured creditors. And these days, I believe, about 10 years ago, they pushed the ATO to rank below these, largely for policy reasons. They want people's entitlements to be paid so that your employees rank higher. You've got unsecured creditors, and then you've got the tax office below that. It used to not be the case, and you'd end up with some quite horrible situations where people had very large tax debts. The tax office would get their money before employees, and unsecured creditors. Those are people who are owed money by the company or the individual that's gone bankrupt that have not created a charge across any property. They get paid next. And so the tax office, I believe these days, ranks below as the last one of those. What happens if there's anything left over? With companies, the shareholders get paid out at some amount of cents per share for anything that's left over, and often there's nothing. That's that process in a nutshell. And Quistclose, I'll get to it. It's so there was an overdraft. There was an account that was set up that said this is specifically for the purpose of paying dividends. And then what happens? They went into liquidation. And so as you could imagine, the liquidators are coming along and saying, we would like that money. And particularly, Barclays Bank just wanted to take the money that was in the account that was labelled for paying the distributions and just offset it against the overdraft. We're just going to offset these two things because that company that's now insolvent owed us this much money and there was this much sitting in that bank account. They're both bank accounts held with us. All right. As a result, we would like that money. And so it trotted off to courts. Quistclose with the lender, by the way. Why would the lender want to find that there was a trust? Because if there is a trust for a particular purpose, and that purpose failed, and it resulted back to the person who gave the money in the first place, which was Quistclose. And there the courts actually said, in this narrow set of circumstances, where there was this specific purpose in mind, and a separate bank account was set up, and it was done with full knowledge of the bank at the time, we will hold that a trust exists. That was the intention at the time. Now, that bit about Barclays Bank knowing and the bit about the intention, those are things that are a little bit more hotly debated these days. But if you do go and read Quistclose, they talk about that at the time. But this led to a bit of horror amongst both commercial, particularly things like commercial money lenders in the 1970s, and a lot of academic commentary at the time as well. But Justice Garmow, alone, and I think he might have been in the federal court, I think sitting alone in the federal court, talked about Quistclose in depth in this Elizabethan Theatre Trust case. And there he said that, look, Quistclose doesn't actually create a huge amount of new law. It wasn't a revolutionary thing. It wasn't a Donahue and Stevenson moment. And that the circumstances where this happened is actually pretty narrow. And it already did happen from time to time. Again, another case, Recaford, the same thing, that Recaford was a mail order company that said quite clearly, when you put money to us, we will hold it in trust in a separate bank account. And of course, they were quite happy to say, yeah, sure, you're holding it in trust. It's quite a straightforward thing to analyze. It doesn't require really reformulating, radically altering the law. It's a narrow set of circumstances. It's not something that's going to come up in a variety, most commercial situations. And you talked about how they would come up. They're looking at the language, going through and analysing what it is that the people creating this set of circumstances actually intended to happen. Was this supposed to go and be used as part of the general funds if an emergency happened, or they stopped that particular line of business? Or was it always supposed to be held specifically for people that Recaford paid into the mail order company and Elizabethan Trust donations that were specifically made? So that if you have a bunch of donations that have been made by people, sometimes these were people just in bucket collections. There you go. Wander around with your little bucket around Circular Quay. In other situations, people are going to send things in and they're going to pay by check. In that situation, you can go and return the money to them. That actually can be done. And just the fact that this combination of things, some money can be returned and some money can't, isn't going to stop us from determining that a trust will exist in that set of circumstances. Does that kind of make sense? It's a fair amount of stuff to get in, to really wrap our heads around. In fact, I might take a break there, actually. Yeah, we're going to go. I'll take a break. We'll take 10 minutes. Maybe to reflect upon the glory of trust law, or to just go get a drink and a sandwich. Sounds good. We're back in 10. I did mention that you have to know what stuff you're dealing with. You have to know what property is actually going to be held on trust. Those two sections from the Trust Act are the two sections that involve vesting. I think it's 82 or 83, both. Basically moving title or moving the names of trustees. The court has that power, it's granted that power under the statute, and it happens in circumstances, usually when your trustees have been naughty. But in order to move title for stuff, you have to know what the stuff is. And so the stuff doesn't have to be described to the minute detail, but it must be ascertainable. So in order for there to be a trust, you have to know what the property is. You don't have to list it, it has to be identifiable. So I give my house in Cairns to my child, to my friend to hold on trust for my child, is going to be fine if I own one house in Cairns, not if I own three. I give my rental property in Cairns, again, is fine if only one of them is rented out, and so on. If it can be identified, that is fine. And again, this is both for the trustees to be able to do their job, and also for the court to be able to change trustees and to vest legal title in others. Often in the event that trustees don't do their job. Occasionally when things like trustees dying, that can happen as well. But there's another more pressing need that I'll be talking about over the next half hour, which is to do with fixed trusts. Fixed trusts are a type of express trust where the amounts of income and capital are set out, are mapped out, usually in the instrument, in the deed itself. That is the settlor's intention, and that requires a little bit more in terms of thoughtfully being able to analyze what the stuff is, because it's something you're going to have to do each year in most sets of circumstances. So this McFarlane-Dalton case, McFarlane-Dalton is one of those big cases. So Quistclose is a big case. McFarlane-Dalton is another big case. When we're going through and trying to determine what stuff is in a fixed trust, because McFarlane-Dalton changed the law in regards to trusts. It did, and I don't have the previous one, which is Golkenbane's trust deed, or Golkenbane's will trust. Golkenbane, G-U-L. Don't ask me the rest. I think it might be the next slide, actually. The next slide? No, I don't have the next slide. I do. It's about 3 or 4 slides further down. Golkenbane, G-U-L-B-E-N-K-I-N. Golkenbane's settlement trusts. That case happened just before McFarlane-Dalton, and McFarlane-Dalton was the opposite. They basically looked at this and said, nah, that's wrong, and changed the law. Okay, but before we move on to McFarlane-Dalton, I'll explain what a fixed trust is. Fixed trust, a trustee has a duty as part of their duties to give out income according to the deed to the beneficiaries in the proportions that are expressed in the deed. If you give to my children X, Y, and Z equally, they will get 33.3% of income. There are 3 children. Okay, pretty straightforward. And again, the same scheme. The numbers can, in theory, be different for capital and for income, usually not. But here I'm thinking largely just in terms of income, because that, in terms of trustees' duty, is something they must do every year. Determine what the income is, and then give it out in the proportions that are explained and expressed in the deed. This is a fixed trust. And that is the opposite of a discretionary trust. Well, the trustee's duty is only to consider. It's only to consider the needs of the beneficiaries that ask throughout the course of a year. They do not have a duty to actually pay them out. That is the massive, very, very large difference between these two types of trusts, these two types of express trusts. Fixed, every year, must pay out the income. Income comes in, generate what it is, pay it out. Discretionary trusts do not have to do that. All right, and that is specified in the instrument, the type. Okay. Now, if things are expressed in the instrument, but not given a percentage, there's a couple of things the courts will follow here. Again, the first is to follow the settlor's intention. So you try and work your way through the deed to try and determine the objective intention of the settlor in that situation. If you can't do that, the PLA actually just says equity is equality. Just do it evenly. Again, it's trying to really be in this position to save trusts. We're trying desperately to save these things as much as we can. The courts will bend over backwards to try and do these things. Now, sometimes you will get vague explanations of the percentage or the fraction or the income that is to be distributed to the beneficiaries. Sometimes the instrument can be expressed in a very, very vague or unusual way. And again, the courts try not to be the destroyer of trusts. And so if an instrument says something along the lines of, I give my 3 children a reasonable amount each year, the courts have actually said that that might actually be fine. And the reason it's fine is that you can actually use objective criteria to determine what a reasonable amount is. We were trying to think just with our lay people, and again, take your lawyer hat off for a second and think about our ordinary conversation we have with our non-lawyery friends. What's a reasonable amount of income in Australia? What do you reckon, James? Yeah, maybe. But could you put a number on it? Maddie? What's a reasonable amount? More than minimum? 50,000. Yeah, there you go. 50,000 might be, maybe that's close to the median wage. And what the courts have said is that that's fine. Sorry, Sean? Usually you would actually go to the ABS. Just go to the Australian Bureau of Statistics, find out what the median wage is in Australia. That can be the reasonable amount. Courts are happy to do that. And look, it's court. When we live in an adversarial court system, and so as such, you'll have people coming up to court. Some want the money, some don't want there to be a trust because they want this trust to be destroyed because they're the residual beneficiaries, for example, of a person's will. And again, I'll talk about and fail. But Regolay's will trust did actually say you can use the expression a reasonable amount of income by going and looking at the data. Courts, people can trot up to court and say reasonable amount of income is this, or just go to the trustee. The ABS suggests that the median wage is this. That can do as a reasonable amount of income, fine. Doesn't work for capital. What's a reasonable amount of, or a reasonable lump sum? Very, very hard to have objective criteria from that. What's a reasonable amount for me to get from my grandmother's will? Depends on a lot of things. And the capital itself that is to be distributed matters too. So that pretty much as a rule of thumb, you can determine a reasonable amount objectively for income, not for capital. That's Regolay's. Okay, and you can, if there's ambiguity, again, in a fixed trust, you can also ask the beneficiaries to sort it out themselves. Hey, the language here is a little bit vague. We don't want to be the destroyer of trusts, but if you guys don't sort this out, it's going to result back to the settlor, and you're getting nothing. It'll go to the residual beneficiaries, usually under that will, or whatever the residual was for that particular person, or back to the settlor to start with. So that is something of a blunt instrument for the courts to actually say, beneficiaries, sort this out between yourselves, or we'll sort it out for you. And if we sort it out for you, it ain't going to go well for you. And that's what happened in Vale and Dalton, which I'll talk about. Let's talk about it now. And the reason why McPhail is important, and we use the phrase the beneficiary principle, because it's trying to work out who are the beneficiaries in a fixed trust. It's real easy. If you've just written down, give the money to my 3 kids, sure, not a problem. Got 3 kids, the instrument says that, no worries. However, things can start to go pear-shaped pretty quick when you start putting open-ended classes into things. And in that, the Re-Gokenbane's will settlement trusts have that exact dilemma. Because it's a really important principle. It sounds a little bit inane, but it's really, really important. In trusts, somebody has to be able to enforce it. There has to be some person, the natural person as a beneficiary, or in the case of charitable trust, the Attorney General, who can actually compel the trustees to do stuff, either by asking them nicely or trotting off to court. There has to be somebody or something who is sui juris who can actually enforce the trust itself. And again, people can do things on behalf. An infant child is still sui juris, even though they probably don't understand much about trust law. Lots of adults are sui juris and don't understand a lot about trust law. But it's that ability at law to enforce a trust. If that can't be satisfied, the trust will fail. And they call that the beneficiary principle, even though, strictly speaking, we're using it to describe both express trust with beneficiaries and charitable trusts as well, which don't have beneficiaries. You're not giving it to people. You're leaving money for income and capital to go towards charitable purposes. And we'll go over that later in the subject, I think later in this lecture as well. All right. So, earlier I mentioned about these powers of appointment. It's a quirky phrase, common law rule. It says you can give your stuff to somebody and give them some restrictions on who they can give it to. Those are powers of appointment. You can do this and allocate it, set up in a will. In fact, that's what it is. In the end, give it to this person, you take my stuff, and then give it to this person over here, or give it to these people, or you choose which people to give it to, or you can give it to anyone you like except yourself, or you can give it to anyone you like except this list of people. All right, these are different powers of appointment. And again, if when doing this and setting up what you think is a power of appointment, but you use mandatory language, you must look after this and hold on to it until my children reach the age of 18, that sounds a lot more trust-like. And in those situations, a trust might actually be determined to exist, and a fiduciary duty might actually arise. But usually it doesn't. When you're giving stuff to people for them to do other things, if they don't do things according to essentially the gift, powers of appointment, you can sue, but you're doing it in common law. Ultra vires, and doing things outside the scope of their power. And for a long time, these powers of appointments lets you create classes of people. Lets you create classes of persons that said, you can take my stuff, give it to anyone you like except these people, or give it to anybody you like who's a resident of Aikenvale. All right, all of those things are fine for powers of appointment. They weren't fine for fixed trusts. And this is where McPhail and Dalton ran into some difficulty to sort of change this area of law. Okay, so Mr. Bertrand Baden, B-R-T-R-A-N-D, Baden, B-A-D-E-N. And you'll actually note in some of the texts, sometimes you'll read this, you'll see these cases, it's actually a series of cases, referred to as Re Baden's Will Trust, semicolon, McPhail and Dalton. So sometimes you'll see that, you'll see this Re Baden. The guy's name was Baden. And he had a company, which all means was quite successful, in the late 1950s, early 1960s, he set up an Inter Vivos Trust. Inter Vivos Trust is a living trust. You do it while you're alive. He set this up, and what he said was, we will leave an amount out on trust, all right, and to be applied towards all current employees, all former employees, all dependents, and all relatives of this particular company. Can't remember the name of the company. So all of the current employees, all of the former employees, all of their relatives, and all of their dependents. And this is where things started to get a bit complex, because that's a class. While in theory, you could go through and name and list, but it's quite a large list. In theory, you could create a fixed list of people. In practice, it's very, very difficult. And so the lawyers that rocked up for this case, the solicitors, your QCs all rocked up. It was quite a large sum of money. And you could imagine, though, this guy set this up, I think he died in 1965. And so the people who've rocked up, some of whom are beneficiaries, who may have been employees, ex-employees, family members, and so on, they've rocked up to court. But the residual beneficiaries of his will rocked up to contest it. Of course they would, because if they can get this struck out as being invalid, which, kind of by the law at the time, we're probably right. If they get it struck down, then it's not a trust. Therefore, the money will result back to the settlor, which means that it forms part of the residual estate, which means that they, as residual beneficiaries, will get all of the money, a large sum of money. So they were quite happy to splash some cash for some QCs and rock up and do this. And what had happened, by the way, in the earlier case, only a year before, that Re Golkenbane's Will Trust, it had gone through multiple levels in the English court system. The Court of Appeal actually reckoned that the fixed trust, they ought to be able to have this idea of what they call conceptual certainty. A trust ought not be invalidated if you can't create a list, provided it's conceptually sound. That's what they said, or Lord Denning said in the Court of Appeal. That was overturned in the House of Lords. And they said, no, that's fine for powers of appointment, but not for trusts. And so a year later, came back to the courts, and this case, the court said, actually, no, this is fine. It's pretty dumb to not have it. So, go something like this. You can, in your trust, both discretionary, fixed, create a list where you list people out. That's fine, you can do that. Or you can create a concept, right? A sound concept, a class of persons. Again, Tom uses the example, all of the residents of Aikenvale. All right, so how would you go about determining that? Well, I don't know, get your power bill to demonstrate that you live there. It's something as an evidential matter. You could probably go through and prove that you lived in Aikenvale or didn't live in Aikenvale. Okay? Now, and so this was actually, I guess, radical or different in terms of how trusts had operated up to that point. And so looking at the McPhail and Dalton case, you've got all current employees. Yeah, sure, that's pretty easy for us to understand. You've got ex-employees. Again, you could probably go through, find some old pay slips or something similar along those lines. Relatives, well, succession law, it looks at things like relatives. We've got to determine whether you're related to the deceased. Not too much of a problem. And dependents. If you're in any of those categories, you don't only have to prove that you were descended from or reliant on those things. These are little evidential things. What they said is that, look, it's not up to the trustee to make the list. So each year, it is not up to the trustee to make the list. The onus rests on a beneficiary seeking to be included as part of that sound concept. Right? The concept is sound. The courts are not going to invalidate it. But people will have to come to the trustee and say, I would like either to be considered for distribution, for a discretionary trust, or I'd just like my money in a fixed trust. Okay, it's up to the beneficiary to do that. Subject, and again, so provided the concept is sound, and they call this conceptual certainty. You may or may not get assessed on that. Reading that as you will. Conceptual certainty, provided that that's fine, McFarlane and Dalton said that if a person can demonstrate that they're in a class or not in a class, it's a yes or a no, it's a binary proposition. If you can do that, then you're going to be fine. And the trust is going to be fine. The trustee can determine whether you're in the class or not in the class of persons. That's conceptual certainty. But some types of classes are going to be evidentially difficult. All right, and that is demonstrating, McFarlane Dalton, for example, if it said something like all of my nice employees, that's not going to be sufficiently conceptually certain because a person can't adduce evidence whether they are nice or not. Maybe you can, maybe it's not a good example. But note that some things like all of my tall employees would probably be fine. Demonstrating that you were tall, again, go to the ABS. Because remember, it is up to the beneficiary to prove they are within the class if they wish to be considered, contemplated for distribution, discretionary trusts, or on a list of fixed trusts. All right, so, okay, there is one exception for that. And this is a question for the cheap, but I'll ask it now. How many trustees are you allowed to have in a discretionary trust? Simon? 4. 4 trustees. That's an old school rule. It's enshrined in the Act these days. But trustees have to make decisions unanimously, and they have to contemplate people collectively and collaboratively. And so Lord Wilberforce said, and he said it with great reluctance in McFarlane Dalton, that this conceptual certainty test is subject to what he calls administrative workability. If the class is so large that it would be impossible to administer, and he said, again, very, very carefully, I don't wish to give an example for fear of prejudicing future cases, but I will anyway. All the residents of Greater London is not administratively workable. All the residents of Greater London is just too many beneficiaries for, he said, this capped number of 4 trustees to go and examine and contemplate a distribution for. That's this rule expressed in entirety is that the test these days is conceptual certainty subject to administrative workability. All the residents of Aikenvale is a large class, probably administratively workable. All the residents of North Queensland is not. Because trustees must contemplate. They don't have to, in discretionary trusts, they don't have to pay money out. Fixed trusts they do, but in discretionary trusts they don't. And they have to actually contemplate, though. You have to actually go through and take steps. You deserve the money and you don't. Again, discretionary trust, subject to how the instrument is structured, but that contemplation is the duty, not the paying in a discretionary trust. Okay, that you have to contemplate the needs of the particular beneficiaries. If you don't contemplate, what can the beneficiary do? They can ask the court to kick you out. As Gina Reinhardt discovered, put in someone else who will contemplate. Again, not pay you, but at least listen to your case to get a distribution for that particular year. Okay. My slides are out of order. That's why that came up afterwards. Okay, and just note, it's the onus is on the beneficiary to prove. So if you are a beneficiary, you have to prove you fall within the sound concept if you want to be considered for a distribution. And a discretionary trust. And that leads on to the next bit. So if you are a beneficiary, the right that you have is not, in a discretionary trust, I'm thinking here, to the stuff. You don't have a proprietary right. Don't have a proprietary right in a discretionary trust. You do have a proprietary right in a fixed trust. It's a really important distinction. In a discretionary trust, as a beneficiary, you only have the right, as in a discretionary trust, to be considered for distribution. You don't have a right every year to get the stuff, to actually get the income or the capital. In a fixed trust, you do. It's a proprietary right. And for those, most of you studied equity, that distinction between them when you have priority disputes, the right to compel good administration from the trustee to be considered, and the right to kick them out if they don't consider you, or they otherwise administer the trust, those are a mere equity. They're a procedural right. Okay, and there's a bunch of them under the Act as well, where they just codify what would have been the rules of equity a long time ago. Now, I love this case. This is really good. Sometimes you get cases in law that are a little bit funny. I mean, it gets a little bit dorky over time because the facts are funny only because we're doing law and we find it funny people would do this. But Cannon and Spryer is one of those. Because Spry QC wrote the textbook on trust law. It's a really, really good example, by the way, that being the smartest person in the room when you trot off to court doesn't make any difference at all. In fact, it can probably count against you because you're not the one making the decision. And so this guy, Mr. Spry, he was very knowledgeable. He was a QC, he was a silk himself. And he wrote texts on equity and trusts. So incidentally, by the way, did Justice Gamow. They both wrote books on trusts. You can see where this is going. So, Mr. Spry QC, and that's not him, by the way, that's actually the wife. Kennan was the trustee that Spry QC put in because he was QC, made a fair amount of cash over the course of his life and put it in a trust. And of course, he knows how trusts work. And it was about, I think, about $8 million or something similar. And so his wife calls him up one day, I want a divorce. And he's like, okay. So what does he do? Calls up the trustee, gets all of the assets moved from what we call the head trust into what's called a subtrust. So basically, the other things moved into a subtrust and basically strips the asset. Very similar to like companies, moving things between company groups. We've got this company stripping the assets and moving them elsewhere. So he does this, and then the wife rocks up, "I'd like my divorce, please," and they're like, "Oh, there's your $100,000 or whatever he'd left in there," and moved the rest of the assets away. And this trotted off to court, and then trotted off to the Court of Appeal, and he argued, and apparently the transcript's funny. I haven't read it, but Justice Gummow and Mr. Spry QC, didn't get along very well. And you could imagine if you, I don't know, both wrote competing textbooks on equity and trusts and things gone up to the High Court, you're standing here and they're standing there. And apparently the transcripts of him calling the judges on the bench a bunch of idiots, apparently they got leaked by the associate to the judges themselves. And so they said some very scathing things throughout the course of the press proceedings. I said, I haven't read the transcript. Anybody can feel free to go to Ostley and confirm that if they like. But a couple of things came from this case. It's actually a big case in family law. Some of you guys done family law? No? Ooh, tumbleweeds, a couple of years. Because it's actually in regards to the Family Law Act. Because one of the arguments that Spry QC made is that when, and you guys are aware, you go through a separation under the Property Law, the Family Law Act, everything gets combined into a pool of assets, both legal and equitable. All right, some equitable interests, remember, can't be assigned, but they're all combined into the pool and calculated and then distributed. Sure, that's right. And with equitable interests, things that are associated with properties that have a proprietary interest, the court can go through and wiggle them around. Proprietary interests can be moved around, but mere equities cannot, because they are procedural in nature. They're not associated with any particular property. It's just a right that you get in equity to do something. A right to rescind a contract for innocent misrepresentation, for example. A right to compel good administration as a beneficiary and a trustee. You can compel the trustees to do their jobs properly. And a right to trot off the court and remove them if they don't. These are mere equities. They aren't proprietary interests under the definition of the Family Law Act. Or so we thought, until this case went before the High Court. And there they said, well, actually, we, under section, I think 106 capital B, the Family Law Act, looking at this definition of property, it's expressed in very broad terms. And we are going to say, in relation to this act, that in this situation, where a mere equity were to compel the rights of the trustee to then do a distribution, in these circumstances, is going to count as a proprietary interest. They looked at a bunch of other factors as well. They looked at how Spry QC had moved all of the assets to the subtrust. And the subtrust was set up not for his benefit, that would be naughty, set up for the benefit of their 3 adult children. And the courts looked at this and said, well, your adult children are actually all very wealthy. They've done pretty all right for themselves here. Clearly, if we look at the substance of this, it's really, the form is just, even if that was precise, substance is to just thwart your ex-wife in this situation. And as a result, we will hold that mere equity, which at some stage will crystallize into a proprietary right. At some stage, you will actually get the right to do this. For example, perpetuities. Perpetuity period. Things might be set out as such that they have to vest within a certain period of time. We will give that a value. It's not a proprietary right as such, but we're going to give it a value within the meaning of the Family Law Act. And that value is going to be $4.5 million. So there we go. It reads a little odd in terms of how the court went and did this, but look at the circumstances that happened with that particular case. That was really one of the principles that came from that as a result. Okay. Yeah, just before we move on, this idea of conceptual certainty and falling within the sound concept and you as the beneficiary having the onus to go through and do that, that's a reasonably important concept to know. and also the idea of the beneficiary having a mere equity and a procedural right. A lot of people don't understand how trusts work. A lot. You guys are going to go out into the world now that you're armed with this information, and you'll be talking about trust with people. And I think this is a component that you really should tuck away in the backs of your mind when you're dealing with trust, and you know of people that have trusts, and you'll see this in legal practice for those 34% of us that go into private practice, that this right for trustees to compel administration can be a very powerful thing. Really, really powerful, because even if you can't get the stuff, you can ask the court to kick the trustees out, put in your mate. Okay, so just leave that one in the back of your mind. It is actually a reasonably important point. All right, so charitable trust we'll do in a bit more depth later on, but I'm going to go through it now in terms of the certainty, because there's no beneficiaries. That's the key thing to note about charitable trusts. You can leave stuff for a charitable purpose, and in ye olden days, and I'm talking the reign of Queen Elizabeth, they set out what those 4 categories are. The alleviation of poverty and sickness, advancing religion, advancing education, and other purposes beneficial to the community. This was restated in Pemsl's case. Probably got the slide? Yes, I do. That's Pemsl's case in the late 1800s. All right, so it used to be, had to fall within those 4 categories. This has been widened by statute in recent times. Actually, since I did the subject as a student, so in the last 10 years, it's been widened to include things like sports. And so a bunch of cases that we would have learned about whether a sport club was education or not, don't have to worry about that. It is now, because the state and federal parliaments have jumped in. Okay, other purposes beneficial to this. So, it's kind of old school. If you actually look at this, times have changed since 1891. For example, you guys are aware in the Australian Constitution, there's no head of power exclusive head of power for the federal parliament to deal with the environment, because the environment didn't exist in 1901. Things that people didn't think of. And at the time when Pemsl's case, which as I said is going back literally and looking at a statute from the reign of Queen Elizabeth I, those things weren't taken into account. And when they're trying to determine whether something is a charity or has a charitable purpose or not, you would look to those 4 limbs. Because there's often a lot of benefits, tax benefits, to having something as being charitable. Charitable trusts don't generally pay income tax. So as a result, if you can get a trust that you've set up not paying tax, that's good for the people that you're leaving this money or this capital income on, because they're not going to be paying tax on it. There's a variety of benefits that flow from that. And so people, a lot of the time, are trying to get things declared to be of a charitable purpose for those reasons. And, of course, what do they want to do? The little weasels. They want to have a charitable purpose, but they really want that charitable, to get all the exemptions, but they also only want to give it to their children. So there's trying to mix and match those 2 principles together. And so you find that these cases have these situations where people are trying to argue that a particular trust that's set up with a charitable purpose, but it's actually just for their ailing grandmother, for example. And again, we've gone on this in a little bit more depth, but that's sort of the lay of the land as to how those things fit together. But the first 2 elements, though, the first 2 components of certainty are the same. That you need to go and actually have intention to create a charitable trust, and you've got to have stuff. The stuff has to be just as certain as the others. It's just this last part. There's no beneficiaries as such, and I haven't talked about it here, but I'll just briefly state the position in Australia in relation to setting things for the management of pets. Can you leave your house to your cat? No, you can't. Cats aren't sui juris, they can't sue or be sued, they're standing in the eyes of the law. Pettingill's case was to do with horses, it's an English case. They argued Pettingill, I think it's Pettingill and Pettingill, Pettingall. Pettingill's case was one where they said, look, somebody left some money to go towards his horses. In the UK, they've been a little bit more liberal with it. They said, yeah, that's fine. That can count as a trust, sure. Here, not so much. Don't try it. Don't try it. It's not going to work. Find some other way. All right, there we go. Right, it's got the 43 Elizabeth Chapter 1, Charitable Uses Act of 1601. The repeal of that statute shall not affect the law. In other words, don't wiggle the common law. We're just getting rid of the old statute from 400 years ago and mapping things out with a little bit more certainty. That's in our Trust Act. And just make note, I use the term beneficiary principle. Beneficiary principle means a trust has to go towards someone or something. And we use the term beneficiary principle to actually apply to both charitable trust and trust for the benefit of persons. So that term gets used for both. I guess it's more an academic point than a practical one. And just make note, there's actually a sliding scale in terms of charities, in terms of how things go and get registered, because a trust for a charitable purpose is not strictly speaking the same as a registered charity under the federal legislation, and that's not the same as a deductible gift recipient. In other words, the ability for people to get tax deductions when they donate to such things. There's a variety of circumstances to that, but we're going to go and spend a little bit more time on that a little bit later, and so I will leave that there, actually. I think we'll probably just leave it there for today. But just, if there's one takeaway, it really is to do with this right as the beneficiary. Beneficiary in a discretionary trust doesn't get stuff. They get the right to do things. Leave that one in the back of your mind. And for those that are going to the shoot, I'll see you at 3 o'clock. 2 o'clock? 3 o'clock. Feel free to correct me on that. Okay. See you there at 2.